claiming that disclosing the information would violate the Privacy Act and the APA. The teams inside the agencies can't look at the agency records was the lawsuit. And so the Doge affiliated agency are tasked with similar broad and open-ended duties, okay? It's the same tasks as any other position in the government. A lot of people get access to databases all the time. You just don't like that it's called Doge.
With the new investments, they're the sovereign investments that we talked about, but then in terms of the committed investment by private industry, we're well over 10 trillion.
Victory for Doge. The bureaucracy having a tough time. The Fourth Circuit Court of Appeals out with a new opinion, and the unions getting blown out. National Federation of Federal Employees, because being a federal employee is not protective enough of you. You need to go have a union too to advocate against the public who are employing you. So we got the American Federation of Teachers, International Association of Machinists. They sued Scott Bessent. They sued Doge. They said, you can't access our records. If you access our records, you're going to find some bad stuff about us, and we have privacy rights and all sorts of things. And so you can't look into us or fire us. So Doge, get out. We're already efficient enough, remember? Now the courts have come down. They say a preliminary injunction, is just that. A decision to grant or deny one doesn't resolve a case. The Supreme Court has said they're preliminary. Now, one feature to preliminary injunctions looms large in this case. The plaintiff must show a likelihood of success on the merits rather than actual success. And as they're going to explain, the lower level court failed and miscalculated their chances of winning. And so we grant a vacating of the grant of a preliminary injunction that the lower level judge issued. Okay, Doge, you're blocked. The block now lifted. They lose. On January 20th, Trump issued an executive order. Doge was unleashed. And it said, create a Doge team in your agencies. And there was an internal command. The Department of Education, OPM, Treasury, they all created Doge teams. They had their own employees there that were on the Doge team. Each agency also created a plan to give its Doge team access to the IT stuff, their own employees. At the Department of Education, Chief Information Officer called Thomas, he issued a memo that authorized the Doge team to have full and prompt access to all unclassified systems and data. Same thing at the OPM. Acting Director Charles Zell requested that the Doge affiliates be added as admins. And at the Department of Treasury, they came up with an engagement plan. Now, shortly after they initiated these, 5 professional organizations and 6 employees sued. How dare you look at our records? Who do you think you are, in charge of the agency? They allege that they or their members have personally identifiable information in the databases. Well, yeah, you work for the government, claiming that disclosing the information would violate the Privacy Act and the APA. The teams inside the agencies can't look at the agency records was the lawsuit. So they sought to stop the agencies from granting IT access to their Doge teams, and the judge granted of that, so they've been stalled for a while. Now, in the meantime, they moved for a TRO to revoke the access that was already given, and on February 24th, after the Doge affiliates at all 3 agencies had given access, the court granted that motion, and so they had to cut off all activity. This effectively paused Doge within those 3 agencies, stalled out thanks to this lower level judge. Now, the government appealed the injunction the same day, also moved to appeal. We granted the motion for a stay and are now appealing it, and as this appeal was pending, the Supreme Court stayed the preliminary injunction in a related case, and so the Supreme Court stay permits these other members to access the record in this other case. Now, this case is very similar to that one, so we got some guidance from the Supreme Court on this. So while the Supreme Court stay of another injunction in the Social Security case is not conclusive on the merits in these other agencies, it is kind of instructive. And so, mindful of what the Supreme Court has just done, we now resolve the government's claims. A district court may only grant a preliminary injunction if it satisfies the 4-factor test. One of those tests is whether they're likely to prevail. And in this case, they face a problem under the factors. To find that these unions and these people will win, they need to find that there's an injury that's ultimately happening. What is the injury? Potential privacy violations? Could be, maybe something. So they don't really know. The district court was required to find that they were going to succeed on the merits. But what it means to succeed on the merits is very obscure. And so there's a structural flaw here. Now, we remain aware that there are different ways to interpret injunctions. The number of obstacles that they must face remains unchanged, and they don't have enough evidence. They don't have enough support for their claim that there will be injuries, and they lack standing as well. First and foremost is standing. They seemingly lack it. They must allege a concrete injury, and it's got to be a recognized injury. There's got to be a factual harm, and we got to be able to redress it. Now, in what they're arguing is they say, well, it's unauthorized access. But intrusion upon seclusion, which is an old common law claim, this was a totally different thing. This is distinct from unauthorized access. And intrusion upon seclusion is an old common law thing. It's usually about your home, and it's not, that harm is not here. To begin with, it's less than clear that entries are part of their seclusion at all. They're not the targets of investigations. No one's looking into their private concerns. These are all public things. Each plaintiff's information is one row in various databases. There are millions of rows. It's not privacy intrusion. Plaintiffs do not allege in their complaint or any row that belongs to them, like that one line, if that's even been looked at. So the harm that might come from looking at a database is not really concrete, and you can't quantify it for this claim. Unauthorized knowledge of sensitive information might apply under other torts, but you got to have public disclosure. Here, there is no public disclosure. But the district court relied on some other cases, and those cases are bad. The same analysis in other cases undermines what the other judge did. A lot of case law analysis here. And even if they don't have standing, okay, even if standing was not enough, there's other reasons they lose. For their APA claim, they must seek review of final agency action, and they don't have that here. The district court below also screwed up by analyzing this Venetian casino case, and their other causes of actions failed too. They said, well, the Administrative Procedures Act, but you can't bring a claim under there. The Supreme Court have implied in the footnotes that Privacy Act does not mean you get equitable relief under the APA, and even if you could overcome all of the prior issues, you can't even establish that there was a Privacy Act violation either. In fact, they can share records. The broader employees' duties related to their needs, and so the Doge affiliated agency are tasked with similar broad and open-ended duties, okay? It's the same tasks as any other position in the government. A lot of people get access to databases all the time. You just don't like that it's called Doge. We do not hold with certainty that they lack standing, that they have not challenged final agency or the Doge can access. We instead come to a statistically sure conclusion. They have failed by a decent margin to show that they're going to prevail on all of these issues combined. They got to win all of them, all right? So the lower level court abused its discretion in finding that they were going to win on each one, and with certainty that they were going to win overall. And so the Supreme Court even has our back. The district court's order is now vacated, and the case is sent back down, and Doge gets access. So this Judge King is dissenting, and he loses. I dissent because of the standard. All right, so good win for Doge over there. Scott Bessent, who's running Treasury and who looks like he just got out of a wind tunnel, was on with Fox Business explaining what the tariffs are doing for America.
Tariff income, I'd been saying $300 billion, but I think we're going to have to substantially revise that up. So well in excess, 1% of GDP. And then with the new investments, they're the sovereign investments that we talked about. But then in terms of the committed investment by private industry, we're well over 10 trillion. So
all right, so tariffs working their way through, and the Doge team is now going to be having access to the rest of the bureaucrats' data, which means hopefully we see some analysis and some reform. And we can free up some people's futures, and they can go find jobs in the private sector.